Hello everyone, thank you for joining us today. We'll be speaking about the recent amendment to the RTI Act under the Data Protection Law. As many of you know, this amendment to the RTI Act has caused some unrest among the experts who know about the provision. It specifically looks at an exemption regarding personal information. Now, at Medianama, we have already covered what this amendment is, but to talk about it in more detail, today we have with us Mr. Shailesh Gandhi, who is the ex-Central Information Commissioner. He was also the convener of the campaign for the protection of the right to information, and he's also a very well-known RTI activist. So, Mr. Gandhi, thank you for joining us today.
Thank you for having me.
Mr. Gandhi, can you start off explaining what the amendment to this RTI Act is?
Before that, in 1 minute, let me give you the basic fundamental background of the right to information concept.
Sure.
Right to information accepts that it's a democracy, and democracy means rule of the people, for the people, by the people. Therefore, all information held by government is held by people. Government holds it on behalf of the people. The elected representatives get legitimacy from the citizens, and they then give legitimacy to the bureaucracy. Therefore, all information belongs to citizens. Default mode in RTI is all information must be shared with citizens. There are few exceptions which are outlined, which are supposed to protect certain interests which need to be protected. For example, the sovereignty of the country, etc. Now, the 10th exemption in the RTI Act was 81J. It said if it is personal information, what is personal? Anything related to a person is personal. If it is personal information which has no connection with any public activity, or which is an intrusion on unwarranted invasion on the privacy of an individual, it may not be given unless there's a larger public interest in disclosure. But with a proviso, see, it was understood when drafting the law that it is difficult for an ordinary.
What is a proviso here?
The proviso is, I was just coming to that. The whole point is Parliament realized that it will be difficult for an ordinary officer to figure out what's a public activity, what's a private activity, what is privacy, what is not privacy. Therefore, it gave an acid test, the proviso, which said provided information that shall not be denied to Parliament or state legislature shall not be denied to any person. Carefully note, it said provided information that shall not be denied. It did not say that will be given to Parliament. Now, if you read the law properly, then it means that if it is personal information, it may fall under 81J, may. Then one has to see, is it a consequence of public activity? 99% of the information held by government of individuals is held in a cause of public activity. If I apply for a government job, it's a public activity. If I'm working with the government, it's a public activity. If I apply for ration, it's a public activity. If I get pension, it's a public activity. 2, is it invasion on privacy? Now, this is a difficult one to define. The Puttaswamy judgment of 550 pages of the Supreme Court, if you read the whole judgment, it does not tell you specifically what constitutes privacy. It gives you various philosophies and theories. And in one place, the judgment says it will evolve on a case-to-case basis as to what constitutes privacy. So try and imagine this situation. Should the government official, when he gets a request for personal information, go to the Supreme Court and say, sir, is this privacy or not? That would be ridiculous. The right way to interpret the law is that whoever says I am claiming exemption under 81J and denying information to the citizen must make a statement that, in my opinion, I would not give this information to Parliament or state legislature. And from where should this concept of privacy come in? Privacy, everything personal is not private. Your name is not a matter of privacy. One way to look at it is, the government has no right to invade my privacy. Routinely, in a routine manner, government cannot invade the privacy of a citizen. Therefore, information that in the normal course of routines the government takes from me is not an invasion on my privacy. And therefore, most of the information should be shared with citizens. The other way of looking at it is what when you place restrictions on my fundamental right under Article 19(1)(a) of the Constitution, it has to be done through the Constitution itself. There has to be a constitutional mandate to say that information can be denied to me. Article 19(2) provides details of areas in which some reasonable restrictions on 19(1)(a) can be placed, which covers sovereignty of India, integrity of India, etc. There are only two words that can relate to privacy: decency or morality. So any information which violates decency or morality should be considered to be in the privacy realm and is information that should not be shared with Parliament, because if it's given to Parliament, it becomes public knowledge. That is the whole logic of this.
Then let me ask you, how are you understanding this term personal information so far? Because there has been some confusion regarding this as well. Do we look at the definitions under the Data Protection Act, or do we understand it in the general sense as you would understand personal information?
No, no. Personal information is information relating to a person. That, I mean, there is no dispute on that. There's nothing to do with the law.
Right. But if you look at the data protection law, it defines what a person is as well, which includes a Hindu undivided family, a firm, a company, any association of individuals, which would include everything. So everything is personal information.
Now, there are two views, and I'm not very sure where the correct view is. One is that person should be read as a normal person, and that you do not have to refer to the DPDP bill for this. The other view, which is also equally valid, is that person should be interpreted as defined in the DPDP bill. And personal is anything related to a person. Therefore, anything relating to a state, company, HUF, individual, everything is barred. So, in my opinion, either way, even if it relates to a natural person, a significant amount of information can be shown to be related to some person, even a natural person. Therefore, in my opinion, this act becomes the right to deny information. Instead of RTI, it becomes an RDI.
Is that one of the reasons why you are also concerned with another provision in the data protection law, which talked about the law overriding all other laws in case of a conflict? So
absolutely. The other position is the DPDP bill talks of information that can be shared or not shared. And if DPDP bill is violated, the penalty can be as high as 250 crore rupees. Now, put yourself in the position of a normal public information officer who's asked to give information. A lot of information may be digital with government also. If he makes an error, he can be fined not 250 crore rupees. I won't stretch it to that absurdity, but he could be fined 1 lakh, 2 lakh rupees. Which government officer is willing to risk that? And it's unfair. Therefore, we were saying that this should not overcome the RTI Act, but may overcome all the other acts. That's the position we are taking.
Would it make more maybe ease some of the confusion and unease than if we maybe introduce another amendment that defines what personal information is under the RTI Act now?
So even if it does, please understand a significant amount of information that is of use to monitor the government, to check its governance, is relating to a natural person.
Right.
In fact, most probably, as the law reads now, amended by the DPDP Act, there's some confusion on whether a separate amendment is required or this itself amends. That I've tried to check with lawyers. Lawyers are also equally confused about this. But nevertheless, either way, that's a minor matter. The point is, most information, going by this, you will not get your mark sheet with an examining body. If you ask for a copy of your corrected mark sheet, your own mark sheet can be denied because it's just personal. It does not talk of personal with respect to who. Today, Jan Sutna portal of Rajasthan gives details of beneficiaries of pensions, which person in which village got how much ration in the last 15 days. Therefore, it helps to weed out ghost employees, ghost cards, and so on. Dead people are. All this will stop. One of the objectives of the Right to Information Act was to curb corruption. The DPDP bill, with the amendment to the RTI Act, makes it an easy thing to be corrupt. All our anti-corruption agencies have failed India. Most developed countries do not have vigilance department in government departments. We have vigilance department in almost every government department. That doesn't work. So we have an anti-corruption bureau. That does not work. So we have a Central Bureau of Investigation. That does not deliver. Therefore, we have a Central Vigilance Commission. वो भी काम नहीं करता है. So we say we now have a Lokpal who does nothing. Citizens are the best monitors against corruption. And this ensures that corruption can continue unhindered and progressive. The other point that is made is larger public interest. It is a very tough choice. Larger public interest has to be shown only when something is exempt. Otherwise, there is no need to show larger public interest. It's my fundamental right. When I speak, I don't have to give reasons why I want to speak. I don't have to demonstrate larger public interest. For a commissioner or for any officer to balance and say there is a harm that should be protected, but there's a larger public interest, hence disclosure. Very rare orders will be like this. Very rare. I was one of the most pro-liberal commissioners, but out of over 20,000 orders that I gave, maybe 3 or 4 orders will be like this. Because that's a very tough choice. If it's exempt, it's simple. The larger public interest clause is there in the law. Even now it is there in 8.2. So that doesn't go away. To say that we'll establish things on larger public interest is making a fool of ourselves.
So, like you mentioned, Section 8.2 is there, which talks about larger public interest. I think the only difference between that and 8.1J is the mention of the specific authority person who can override this.
Which is minor, which is a minor issue in my opinion.
Then,
but I'm submitting that the controversy on that is a non-event.
Okay.
Whether it is in 8.2 or 8.1J, the actual number of orders given after conceding an exemption will be very rare. The clause is important. I'm not saying the clause is not important. But in actual practice, on the ground, the number of orders that you get on larger public interest after conceding an exemption are very, very few. And it is understandable that there will be very few. Let me try and put it in simple terms. Supposing some information is sought about Mr. X, personal information, which the commission and everybody feels violates privacy. He comes to the conclusion that I will not give it to Parliament. Now he has to judge, is there a larger public interest in disclosure compared to the harm to Mr. X? The larger public interest clause is an important clause, but in actual practice, very few orders are given on larger public interest basis. People may say it is not exempt and there is a larger public interest. That's a different question. But to concede and say that this is exempt, but I'm ordering that it should be given, though it would not be given to Parliament, it should be given to the citizen. Such orders are extremely rare. So people fighting about the larger public interest is a sham. Sham in the sense it doesn't deliver any great benefit to in most cases.
One minor question that I also had as a journalist who has to regularly file RTIs Would this personal information also extend to deceased persons or any kind of artificial intelligence that uses personal information?
See, personal information, it depends entirely on your imagination.
Okay.
Let me give you a concrete example of even now as the law stands, even with the law saying all this, there are a lot of orders of commissioners, PIOs, and courts which have not considered all the limbs of 81J and have said personal information therefore shall not be given, which is an illegal order as of now. And this amendment is an acknowledgement of the fact that these orders are illegal. I had filed 3-4 years back with DOPT in asking information about number of IAS officers whose annual confidential reports had not been received for 1 year, 2 years, 3 years, and 4 years. Just numbers. The PIO was imaginative. He said this relates to persons. Hence, I will not give it under 8.8. Even without this, with this amendment, it makes it legal. So it's a matter of your imagination. Ultimately, look at it like this. If you say, I want a copy of this order given by this department, the order will be signed by somebody. Who signed this? Person Y signed this. Therefore, it is personal information shall not be given. It actually can result in 90% of the information being denied, 90-95%. Only thing you might get is budgets. And budget also, if somebody imaginatively relates person to state from DPTP bill and says even state ka nahi dunga budget. So it entirely depends on how it operates. But it is certainly very threatening. It is almost, I repeat, rendering right to information into a right to deny information. The denial of information will become primary. A PIO will give information depending on his sweet will. Most information he will find a way of relating to a person. Ghost employees, corruption charges, all of this goes under the personal thing. Section 81J had 87 words. It is now being reduced to 6. So they're making the law shorter, but with no benefit. It's, in fact, I almost feel that greater importance to this is not the data protection. Greater importance to this is the right to information amendment.
Another minor question of sorts. Again, this is from a person who files an RTI to appeal an RTI. Now, usually, if I have to appeal, I typically sometimes use the larger public interest defense when making my first appeal. So usually I send it to the relevant authority under the RTI Act. Now, do I send it to the Data Protection Board or would I send it to the appellate authority under the RTI?
No, there's no larger public interest.
No.
Okay, let me ask you, since you find the number of RTI applications, in how many RTI applications did somebody say it is exempt under this, but there's a larger public interest?
No, I understood your point. I'm saying suppose I do want to appeal under any argument. So, for the sake of this clause, I'm saying I have some contention. I want to challenge the denial of information. Do I go to the board or do I go to the RTI authority?
From the RTI perspective, you go to the first appellate authority.
Okay, so it's still the same as before. Then that
it should be. What may happen? How imagination may run wild in government departments to deny information. I can't make a definite prediction. Like I told you, even with the existing 81J, this number of persons was denied by DOPT. So people are very imaginative and creative in denying information, as even now. Even illegally, they deny information. With the law becoming so strong against giving information, heaven save us.
I remember there was another amendment a few years or maybe around 4 years ago where they had changed the clause relating to their salaries, officer salaries and tenures. At that time, media had covered the amendment at length. I remember you were also doing a lot of interviews at the time, but now I don't see as much talk about this amendment specifically. Why do you think that is?
You see, people feel RTI amendment is bad. General impression. This is going under the guise of data protection. So the average media person, the average citizen, the average elite thinks ये कुछ मेरे लिए अच्छा है. And I have realized that most people, it's a weakness with most of us, or whatever way you look at it, feel information about themselves should not be shared anywhere. Whether it matters or not doesn't matter. But mera information is, I'm very special. Then the ego takes over.
All right. Another thing is, I think the news came out either today or yesterday evening. On the RTI online portal, the archives of all the RTIs that have been filed and answered as far back as 2013, they have now been erased. Do you have any response to this information?
Which is bad, but even now, let me honestly admit, it was of limited usage. As represented, it would be used effectively, provided it had categorization by name of PIO, name of applicant, subject matter, etc. There was no such categorization. So it was just like a dump of thousands of RT applications. How do you use it? If you want to use it to figure out whether an RTI has been filed before, you will either search it by the name of the applicant, name of PIO, or subject matter. If none of this is there, you go through thousands of RT applications. Unfortunately, that had not been done. So to my mind, look, citizens at times worry about the smallest challenge to their thing and don't worry about the larger issue. In my opinion, these two, 38(2) section and 44(3) section of the DPDP bill are a very fundamental regression on our democracy, are a very fundamental attack on our fundamental rights. It's unfortunate. I had written an appeal to various media people who I know, saying, please talk about this. Discuss it. I'm not saying you agree with what we are saying, but at least discuss it. It is not being noticed. This, compared to the amendments 4 years back, that was very minor. The amendment had a very minor impact on the RTI. This is going to have a major impact. I repeat, it's going to change RTI into RDI, right to deny information. But it's being slipped into the DPDP bill. If they brought it separately, probably there would have been a greater outcry. Here, people feel, oh, it's data protection. So, mera file hai.
Do you have any advice for us RTI applicants about what we should do from here on forward?
In my opinion, this is a major setback for the RTI. With this, if it's allowed to continue like this for the next 3 to 5 years, it may not have immediate impact because a lot of people may not understand what's happening at ground level. But over a period of time, this will become a law which is completely useless. Now, what can we do and what should we do? In my opinion, first is media. I wish we can shake up media. I'm thankful to you for doing this interview. But citizens must discuss this. Media, citizens together must discuss this. Have discussions all over the country. Make it a live issue. Tell political parties that in your manifesto, we want an assurance that these will be taken back. I believe we can influence the political system provided we make the effort, provided it becomes sensitive. I wish, like Media Nama, all other media bodies also were to take up this issue. Discuss it, interviews, let government explain its positions and so on and so forth. We can get this to be changed. 75 years back, we were able to convince a foreign government to leave India. Surely now we can, this is our own government. Surely we can make it change. Maybe they've not seen things properly. But we need to create a large public opinion, which can happen only with media support. Without media support, it will not happen. I concede completely. There's an article I have written, which I'm sharing with various people and saying either publish this or write your own article, write your own editorials. Even if you disagree with me, please go ahead and do that. Let it come into media space. Today, it is not in front of the agenda of the country. Most people are not even aware of what is happening. That we need to do. Unless we do that, we have got a major setback for democracy. Compared to one incident here, one incident there, in my opinion, this deserves as much space as this Chandrayaan. This deserves as much attention. When your fundamental right is getting compromised, if we are quiet, we don't deserve our freedom, we don't deserve our democracy. And if we do act, I'm sure we can pull it back.
Thank you, Mr. Gandhi. I remember you had also filed a change.org petition where you had asked many people to please sign up the petition so there can be more awareness about this issue. I hope more people go and check that petition also after this interview goes up on our site. For our viewers, thank you for joining us. Thank you, Mr. Gandhi, for joining us and explaining, and at least for me, sorting out a lot of some of the confusions I had regarding this amendment.
If there's any other confusion, tell me. I'll be glad to sort it out.
Definitely. Thank you very much for joining us, everyone. For more information, please do connect with Media Nama. Thank you, Mr. Gandhi.
Thank you, Valdari, and thanks to Media Nama. Goodbye.